I have had a complaint from a member of police staff.
Well, first of all, could you identify yourself on me?
Yes, certainly. My name's Sergeant 1789 Pope. I'm the duty sergeant on today. Got no issue with your video. That said, I'd ask you not to video inside there, members of police staff. If your actions cause alarm, harassment, distress to them, you may commit an offence.
Okay, right. Well, just so you know, that is a public area, okay, and I'm well within my rights to be in there and filming. Okay.
Sir, I'm not saying you are. I'm saying if your actions cause alarm, harassment, distress.
Okay.
Members of the you listen.
As an officer, okay,
please
you
listen,
can't
sir,
be alarmed and distressed.
Actually, we can.
No, you cannot. You need to look at case law, and you will actually see that you cannot be alarm and distress right in your actual officer's
that's the
duty.
case of RV Oram. That's not in relation to what we're doing now. I'm talking about police staff, not police officers.
Okay.
Sir, I'm talking about police staff, not police.
The sergeant attempts to stretch the law, suggesting that filming inside a police station could amount to harassment, alarm, or distress if it unsettles police staff. But that argument quickly unravels under scrutiny. Plaud immediately challenges the claim, exposing its weakness. Police officers cannot simply redefine lawful filming as an offense because it makes them uncomfortable while they are on duty. Shifting the focus to staff does nothing to strengthen the point. Police staff remain public employees operating within a public-facing environment. As public servants, the threshold for what constitutes harassment must be higher, not lower, than it is for private individuals. If merely recording inside a station were enough to qualify as harassment, it would effectively shut down public oversight altogether, undermining transparency and stripping away a critical layer of accountability in policing.
If the members of staff cause alarm, harassment and distress, I'm telling you now that may be an offence.
I'm allowed to film anything I can see from public.
I'm not saying that you
okay? So if I film them, if I film them and I'm in public, okay, then I am doing nothing unlawful. Nothing.
Nothing.
Okay, correct.
Right, so if you cause alarm, harassment and distress through your actions, okay, then you commit an offence on Section 5 of the Public Order Act.
Section 5?
Okay,
so have you got a member of the public that's a complainant?
I'm not saying that you've done that yet, but I'm not saying, I'm just advising you. I've got no problem with you videoing here.
Well, have you got a member of the public that's a complainant?
Well, police staff
is not a member of the public. No, they are not. Not when they're actually working.
They are?
Not when they're working, sir. You need to actually justify that. They are police staff and they're in an office of duty.
When Plaud calmly explains that he is doing nothing wrong by filming in a public place, the sergeant pivots to a familiar tactic, invoking Section 5 of the Public Order Act 1986 and warning that filming could become an offense if it causes harassment, alarm, or distress. On the surface, it sounds authoritative, but in reality, it sidesteps what the law actually requires. Section 5 applies only to behavior that is threatening, abusive, or disorderly, standards that are clearly not met by quietly filming through a doorway. What's really happening here is an attempt to reframe personal discomfort as criminal conduct. Yet the courts have consistently drawn a firm line. Mere annoyance or unease does not meet the legal threshold. The behavior must cross into something genuinely abusive or disorderly. Plaud's calm, composed filming in a public space falls nowhere near that boundary. And if simply using a camera were enough to trigger Section 5, it would open the door to a troubling precedent, where journalists, photographers, and even tourists could be treated as offenders for doing nothing more than documenting what they can lawfully see.
You need to actually rectify that.
So I would ask you, very politely, okay, not to video the staff. If you want to video us, that's fine. You're more than happy to do so.
No, I will video the staff if they're actually in the
if I do get a complaint, so then you may be dealt with under that matter, okay?
Well,
and that's it. That's the end of it.
Just remember, it will be completely unlawful. It will be completely unlawful. Okay, but also, can I just mention to you as well, can you tell me why you didn't actually tell me that you put your body camera on, sir?
Okay. I apologise for that. My body camera's on. Is there a reason why you didn't tell me you were videoing me?
I don't need to. Okay, under your actual code of ethics.
Thank you very much for your time, sir. So yes, go on. Under my code of ethics.
Under your code of ethics, under section 3.5, okay, you're meant
3.5 what?
3.5 of your code of ethics.
Sir, there's no such thing as 3.5.
Yes, there is. Yes, there is, sir. You need to actually look at it, okay? It actually states that a member of the public must be informed at the first possible moment when you actually turn your body camera on.
When Plaud notices that the sergeant's body-worn camera is already recording, he raises a straightforward and reasonable question. why he wasn't informed, given that police officers are generally expected to be transparent when recording members of the public. Instead of addressing that point, the sergeant deflects by asking why Plod didn't announce his own filming, a response that misses the core issue entirely. Members of the public are under no legal obligation to declare when they are recording in a public space, whereas officers are held to professional standards that emphasize openness and accountability. Plod continues to press the matter, referencing the College of Policing's Code of Ethics, which clearly identifies transparency as a fundamental principle of policing conduct. Against that backdrop, the sergeant's suggestion that no such expectation exists does not stand up to scrutiny. The guidance is clear. Officers are expected to act openly and honestly when recording, especially since body-worn footage forms part of the official evidential record and can later be relied upon in legal proceedings.
You had ample opportunity in which to actually tell me.
Can you just wait?
Okay,
Stop
and you did not. No, please don't talk to me that way.
What I'm going to do is I'm going to give you a card.
To me in that manner.
Sir, I'm going to give you a card with my details on so you can make a complaint that I didn't inform you.
Don't worry, I will be.
That I had my body-worn video.
I will be. Don't worry about that.
I didn't. I was more concerned with your actions at the time. But
what, my actions? What, filming in public?
What? No, what you're trying to
filming
do...
in public,
No,
sir.
what you're trying to do is just bait police officers and other people.
That's a presumption, okay? What you got to remember, a presumption, okay, that's your own personal presumption, sir.
I'll give you my details.
Okay, your own personal presumption. And your own personal presumption is not law.
I'm just advising you.
Okay?
If you watch the video
your
public,
presumption is not law.
No, it's not.
Okay? So just remember that.
I never said it was.
Okay? So don't tell me that I'm trying to bait police officers.
You are?
No, I would have gladly have had a nice conversation with you, sir, if you would have approached me in a different manner.
You were never intending that at all.
Really?
Really? You're doing this specifically because
sir, you're making another presumption again.
I've come out to speak
How have
to
you made it
because
as a sergeant? How have you made it as a sergeant when you make so many presumptions, okay? You've made 3 different presumptions.
This is where the sergeant's conduct becomes most revealing. Instead of grounding his response in facts or identifying any clear legal breach, he repeatedly speculates that Plod is simply there to bait officers, an accusation based on assumption rather than evidence. An officer, particularly a sergeant, has no authority to assign intent in place of law when the underlying conduct is lawful. Filming in a public place is not an offense. Full stop. The role of a sergeant is to apply the law accurately and impartially, not to speculate about motives or construct narratives around a person's presence. By characterizing Plod's lawful recording as baiting, the sergeant effectively exposes the weakness of his position. Unable to point to any genuine offense, he shifts away from legal reasoning and instead focuses on discrediting the individual behind the camera, turning from law enforcement into interpretation of intent.
Now, if that was the case, I can make a presumption on you and say, right, you're in uniform, okay? Are you telling me that you're going to murder someone next? Okay? Is that what it is? Okay? So I can make a presumption, okay, on you, okay? And this is only using it as an example. So are you telling me then that you would actually murder someone else, would you, sir? Don't do that, you prick!
What are you doing?
You're such a prick! Okay? No, you deliberately push that to try and push me over. Okay? And don't make it look like you weren't.
Please don't shout at me in the inquiry.
I'm not shouting, sir.
Are you here for a legitimate reason?
Okay?
Are you here for a legitimate reason?
Well, what I'm here to see, okay, I will go and see.
Are you here for a legitimate reason?
Yes, I am here for a legitimate reason.
Do you need to speak to someone? Would you like to tell me what that is? And I'll get an officer to come
Not you,
speak to you.
it's your actual inspector I would like to see.
He's not here at the moment, but I can give you the details on how you can contact him.
Yep, if you could. Okay, because that was completely out of order.
If you contact 101...
No, I'm not doing it via 101, okay? I will actually do it in here.
They'll take the details for you.
And that I will do.
Okay.
Okay? But you are absolutely out of order for what you just done. Don't make it look like you didn't do anything. It's all on camera. No, was it hell?
This is the moment the situation escalates sharply, as the sergeant heads back into the station through the revolving door, with Plod following behind. In an abrupt move, he suddenly brings the door to a stop, causing the panel to swing back forcefully into Plod. The incident immediately raises serious concerns, as it appears to go beyond a simple accident and instead reflects a moment of clear frustration from a senior officer. Regardless of intent, any action involving physical contact in this context is highly unprofessional and difficult to justify. When Plod confronts him, the sergeant denies any wrongdoing, but the footage becomes central to the dispute, showing exactly how the interaction unfolded. Whether interpreted as deliberate or not, the incident is now documented evidence and is no longer just a matter of conflicting accounts. Once placed under legal scrutiny, such moments are assessed objectively, and responsibility is ultimately determined through formal investigation and, if necessary, the courts.
Absolutely talk out your arse.
Sir, if you keep swearing at me and you keep being abusive, then I will ask you to leave the station. Sir, I'm going to ask you to leave the station if you carry on trying to behave in this manner.
Can you tell me whether or not that is swearing or not? Arse is not swearing.
Yeah, you're shouting at me.
I'm not shouting.
You are.
I'm not shouting.
If you want to make your complaint, there's the inquiry office.
I'm not shouting.
I'm more than happy to do so. If you have no legitimate reason to be here, I will ask you to leave.
I have a legitimate reason. Okay.
What's your legitimate reason?
Well, I'm waiting for you to go, and then I'll go in there.
Okay. Thank you very much.
Okay. Well, I'll wait for you to go.
Thank you.
Okay. Because you are absolutely out of order.
Sir, there's no point following me in.
I'm not following you in through that door. I'm not following you in through that door. No, I want you to go, and then I'll carry on with my business.
Okay.
And I've already told you that 3 times. As soon as you go, I will carry on with my business.
You're just being argumentative unnecessarily.
Okay. No, you tried to push me over.
I didn't.
Yes, you did. It's all on camera, so don't worry about it.
It's all on camera.
Yep, and I will be getting a copy of those.
I'm sure you will, sir. You have a nice day. Thank you for your time.
Right.
Just a quick thing for you, just to give you a quick update on this, is you've got this sergeant here at Poole Police Station where you'll hear him make a number of different presumptions about myself and so on and so forth, and then we go into the building. He goes through the actual turnstile door in front of me, he pushes it really fast, the door behind me slams into the back of me, and then he tries to act like nothing actually happened. And from their own camera footage, it's actually come out, it was full-on assault is what it actually was, because it was deliberately done. And basically they've offered £1,250, which has been declined. I'm not interested in that, and basically, so we're going to push through and actually hopefully get this type of copper that should not be on our streets in the UK or anywhere else, and hopefully go from there.
Claude explains that the incident was captured on the police station's own CCTV and later treated as a deliberate assault, leading the force to offer Claude a £1,250 settlement in an attempt to resolve the matter quietly, an offer he refused, insisting the issue was about accountability rather than financial gain. He is now pursuing the case through the courts, where any award could potentially range from £5,000 to £15,000 or more depending on the findings. However, the greater consequence would be a formal ruling on the conduct itself, which could trigger disciplinary proceedings against the sergeant, including suspension, demotion, or dismissal. In hindsight, the pattern of failures becomes clearer. The sergeant relied on unsupported harassment claims, dismissed established professional standards, and repeatedly substituted assumptions about Claude's intent for proper legal judgment. What emerges is a picture of frustration overriding procedure. The confrontation ultimately culminated in the revolving door incident, a moment that transformed a routine interaction into a recorded allegation of assault and a potentially serious legal case. What should have been a controlled and professional disengagement instead highlighted the risks when training, judgment, and restraint break down under pressure. By choosing to pursue the matter through the courts, Claude ensures that these claims and actions will now be tested openly and independently. And with that, the case moves from a street-level dispute to a formal legal examination of conduct, accountability, and authority.